outside of task force members, but
I'm Ann Terrell,
and John Cobain is Deputy Commissioner.
And Margolis, staff department.
Great. And Chris will answer to, if you have a question for Noel, Chris will be happy.
I don't know how to do Noel.
Yeah, excellent, great. So thanks very much, everybody, for joining us. First of all, are there any questions about the agenda or suggestions from the task force for changes to the agenda? Okay, not seeing any. Just want to acknowledge the fact that we were actually successful with our doodle poll effort and in terms of scheduling future meetings so that we could actually get several in advance. So if you look at the bottom of the agenda, you'll see the next meeting scheduled November 3rd, November 13th, December 3rd, December 17th. And hopefully we'll be able to get our work done through that process. But we are on a very tight time frame in the sense that we do have an obligation to report to the legislature January 15th. And so we need to do multiple meetings a month in order to get that done. And I appreciate everybody's attention to that. So today, you recall last time we heard the description from based on the comprehensive energy plan, kind of what the task is before us with regard to renewable energy in Vermont, in order to meet our goals, what the magnitude of that is, that it is feasible, and that there are challenges associated with it. Today, we're going to get an overview of Act 250 and 248 from. Then we'll be talking about various experiences that people have from a planning point of view, from the town's point of view, and from a developer's point of view. We'll repeat this next month with more testimony from people that are affected by these projects and how they have experienced them. We give the task force some information about what the issues are, and then we will be then spending really the bulk of the rest of the time talking about those issues and suggesting conclusions about what we think should happen. As part of that, we all, as task force members, have a little bit of a homework assignment for next time, which is to look at the information you've received so far, recognizing it's not necessarily complete, and come in to the next meeting with your suggested list of issues or solutions to the problems that you've seen so far. And we'll compile those and then start to discuss them. So I'd ask each task force member to think about that over the course of the next couple of weeks. And in the November 3rd meeting, be able to bring with you a list of things that you feel we should be addressing here. So with that, let's move to the approval of the minutes, the September 17th meeting minutes. Has everybody gotten to look at those, and can I get a motion?
So moved.
Moved by Sharon.
Second.
Seconded by Ian. Thank you. Any discussion on the minutes? Okay, seeing none, let's take a vote. All those in favor of the minutes about September 17th as presented, signify by saying aye.
Aye.
Opposed? Any abstentions?
Chris.
One abstention from Chris. Okay, thanks. We've approved the minutes. All right, so we're going to move on to the Act 250 and 248 discussion. We've got about 40 minutes scheduled on the agenda. I'd like to leave about 20 of that, for, if possible, for question and answer from both the panel and from, if appropriate, from the members of the public as needed. So let's start with John Groban, who's the chair of the Natural Resources Board. And thank you, John, and for joining us. I really appreciate it. And Lou Morty as well from the Natural Resources Board. So thanks for joining us.
Well, thanks, Commissioner. Happy to be here to provide a brief overview of Act 250. Very brief. Act 250 is complicated and involved, but Lou Morty, our very extremely capable executive director, has distilled it down to kind of the simplest, barest tones so we can get more of the question part of it. So with that, I'll turn it over to Lou Morty. So thanks, Lou.
Okay.
provide an overview of the Act 250 process. It's, it is a complicated process, but what we'll do is just go through the basic elements of Act 250, how it works, the district commission process, and then, if there are areas that you'd like to flesh out, if there are questions, we can address those afterwards. So Act 250 is a law which provides for a citizen-based quasi-judicial process for reviewing and managing the environmental, social, and fiscal consequences of major subdivisions and developments in Berkeley. Not every development project needs to go through Act 250. There are certain thresholds, which I'll cover in a minute. But when the law was established in 1970, the legislature basically adopted certain thresholds that would trigger Act 250, which is a statewide review that takes place in addition to any local review that may occur in a particular town. And I think one of the hallmarks of the Act 250 process is the citizen-based nature of it. Decisions are made by district commissions. There are 9 district commissions in the state, and I'll explain that more in a minute. But district commissioners are lay people who are appointed by the governor. They represent their region, so they can kind of represent the local context, local flavor, and some local knowledge, and incorporate that into the decision-making process within the context of a quasi-judicial process that has to be based on evidence. So obviously the decisions have to be based on evidence in the record. But the commissioners add that local context. Just quickly, our organizational structure, like the Public Service Board, our program is governed by an actual board, of which John is the chair. The other members of the board, again, are essentially volunteers, appointed board members. Chair is full-time, and then we have a staff here in Montpelier of 7 total, which includes 2 attorneys, myself, executive director, some administrative support. But really the heart of the process is what happens down here at the district commission level. Again, with the 9 district commissions, we have a total of 7 members of each district commission, and they serve 2 to 4 year terms. So that's really the part of the process is at the district level. We provide support. We oversee the process. We provide legal support as well, but the decisions can be made at the local level. Again, 9 districts. They generally follow county lines. In some cases, a single county, like Chittenden or Addison County. In some cases, there are multiple counties, like Northeast Kingdom includes Caledonia, Essex, and Orleans counties. So the districts vary in size, but generally they do follow county lines, with the exception of District 2, which goes right through the Windsor County. Our offices are located, our field offices where the district commission staff work are in Essex Junction, Barry, St. Johnsburg, Springfield, and Drummond. Again, the district commission is a quasi-judicial body. Members appointed by the governor, not full-time. They work on a per diem basis. For any particular Act 250 application, 3 of the district commission members are assigned to that case. They become the panel essentially for that case. And a quorum of 2 is required to make a decision on the application. The district coordinator plays a really critical role. They are essentially the full-time staff of this district commission. They're full-time employees. So in addition to working with the district commission, they also provide assistance to applicants. They help applicants prepare their applications and make sure that the applications are complete. But they're also advising parties who may want to participate in the process, and just kind of being the point person for the general public. They're really kind of a hub of a wheel that Act 250 is. And so they're really the center of that process. And again, since it's a quasi-judicial judicial process. All evidence that's submitted to the district commission has to be distributed to all parties, and in order to get to the commission, the evidence must be submitted to the district coordinator, who ensures that, again, the rules of evidence and there's a judicial processes that is observed. So I mentioned jurisdiction. Not every development project in Vermont, of course, has to go through Act 50 or triggers Act 50, but this just gives you a sampling of the types of projects that are required to obtain an Act 50 permit. Subdivisions, 10 lots or more, or 6 lots in certain towns. Commercial development on more than 1 acre or 10 acres, again, depending on a particular town, whether they have permanent zoning and subdivision regulations. State and municipal projects that involve more than 10 acres of actual disturbance, so disturbance of the land, not the size of the tract of land, which is the standard for commercial development jurisdiction. Housing projects with 10 or more units, that's kind of the basic threshold, but in designated centers, that threshold is higher depending on the size of the municipality. So in Burlington, for instance, that threshold goes up to 200 units. Build 200 units, it's a priority housing project without an active unit. And that is, of course, to promote development in our downtowns and designated centers. Communication towers, if they're more than 50 feet in height, require an Act 50 permit. Almost any development, commercial, residential, or industrial development above the elevation of 2,500 feet, where they're much more, those areas are much more sensitive, the soils are thinner, and many of those areas are not really appropriate for development. Most of that type of development above 2,500 feet that we see is logging, which does require a permit. Material change is basically, if you have a permit and you want to make a change to the project, you need an amendment to the permit, and then substantial changes are changes to projects which predate Act 250. So they can continue to operate unless there's a substantial change. It's basically a grandfathering provision. There are some exemptions. Farming and logging, when they're below the elevation of 2,500 feet. Electric generation and transmission facilities and telecommunications projects regulated by the Public Service Board through Section 248 and 248A automatically do not require an Act 50 permit. Agricultural fairs and horse shows, if they don't involve new buildings and if they're open to the public for less than 61 days per year. And then a relatively new category of exemption is small scale on-farm composting. Because there are a number of categories of jurisdiction, and some of them are not necessarily straightforward, there is a process by which anyone really can obtain a jurisdictional opinion from the district coordinator. They have the authority to issue binding jurisdictional opinions, which is a determination of Act 250 jurisdiction over a particular project. Most of those are done in the form of what's called a project review sheet, which is a simple form. It's filled out electronically. If it's a more complicated project, it involves more explanation of the statute and the features of the project and how it, does or does not trigger jurisdiction. The jurisdictional opinion can be done in a letter form. The coordinator can reconsider that within 30 days, and then there is an appeal to the Environmental Division. However, prior to actually getting to the Environmental Division, the person who requested the jurisdictional opinion must ask the Natural Resources Board for reconsideration. So the Natural Resources Board has the opportunity to essentially provide a second opinion at that point, prior to that jurisdictional opinion going to the Environmental Division. And that's a relatively quick review. This is really it in a nutshell. Obviously, there's a lot more detail, but just to give you a sense of how it flows and sort of the tiers of applications that we have in the process. The first step is the completeness review, which is done by the staff, by the district coordinator. And generally, our performance standards are 7 days for that review to take place. Once the application has been determined to be complete, the application is sent to the district commission for their determination of whether or not it will be processed as a major or minor application. So we have basically 2 different application review processes, and about 80% of applications are processed as minors. The main difference between those and the 20% of applications that are processed as majors is that there's no hearing schedule up front for minor applications. There's a comment period. We use a notice published in the newspaper. There's a draft permit that is prepared. And during a 20-day comment period, anyone can review that draft permit, and if they have, if they are entitled to party status for over a minute and they have a valid concern, they can request a hearing, which the district commission would then schedule. The other 20% of applications are processed right from the start as majors, and a hearing is scheduled within 40 days of the application being complete. And the difference, or the kind of deciding factor between the major and the minor, is that after the district commission reviews the application initially, if the commission determines that there is demonstrable likelihood that the project will not present significant adverse impact under any of the 10 criteria, then they can send it along the minor review route. It's not a question of how large or how small the project is. It's whether or not the applicant has really addressed the 10 criteria and it's really provided sufficient information in the application itself to demonstrate that they meet the criteria without the necessity of a hearing. So some actually fairly large projects are processed as minors. Conversely, some fairly small projects are processed with a hearing or require a hearing in the major process. So it really just depends on whether or not there are significant issues which require a public hearing and more opportunity for the commission to review the project at hearing. I mentioned party status. That's a pretty important part of the process for either majors or minors. The rules of party status or the statutory requirements apply, and essentially the applicant and the landowner, is not the 2 separate parties, have automatic party status, as well as the municipality, which includes both the governing body as well as the planning commission, so they have separate party status. Any state agency affected by the project, they are all entitled to automatic party status. So basically A through D, those categories are entitled to party status. They don't have to request party status. They can hear or comment, provide comments on really any aspect of the application and any of the criteria. Category E are really parties that have to demonstrate a particularized interest that has to be related to one of the criteria. So it has to relate to the issues which the commission is reviewing. You have to have an interest which is different from the interest of the general public, so that's what makes it particularized. And they have to, they have to provide some indication that their interests may be affected by the project. That's a relatively low bar. You don't have to provide reams of evidence to demonstrate that you have an interest that may be affected, but you have to at least provide some indication up front that your interest is particularized and it may be affected. And then the last category, friends of the commission. Commission can allow anyone, any group, any individual to participate, and they can participate at any level. They have full participation rights in terms of providing evidence, cross-examining, that type of thing, or it could be more limited. But the key is that they do not have appeal rights. So that's what distinguishes friends from the other parties. The criteria. 10 criteria are actually more like 27 criteria if you include the sub-criteria under criterion 1 and criterion 8. But they're sort of grouped in the rough categories. Criteria 1 through 4 really deal with air and water pollution, and water supply, and then soil erosion, which is really focused on water pollution as well. So those are sort of the scientific criteria that deal with air and water pollution. Under those criteria, there are about a dozen permits issued by other agencies, mostly the agency of natural resources, which can serve as presumptions of compliance for criteria 1 through 4. So if you obtain one of those permits, provide that permit to the district commission, that automatically serves as a presumption that you met that particular criteria. It might be a wastewater permit, it might be a wetlands permit, it might be a stormwater permit. So once you have obtained that, you don't have to then explain from the beginning how the project complies with that aspect of those criteria in Act 50. Unless the permit is challenged, and there's a process for doing that. It's fairly rare. It's fairly rare that happens, but there's a process for someone to actually try to rebut that presumption. Criteria 5 through 7 are sort of the local criteria, although transportation can certainly have more regional and statewide impacts. But generally, criterion 5, transportation, safety, and congestion. Criterion 6, its impact on the municipal educational system. Criterion 7, impact on other municipal services like fire protection, police, rescue services, that kind of thing. So those are mostly focused on local impacts. And then criterion 8 is somewhat of a catch-all that includes wildlife habitat, necessary wildlife habitat, historic sites, and then scenic and natural beauty and aesthetics. And the district commissions use the reaching analysis, which I believe the board also uses as a framework for analyzing aesthetics. That was an analysis that came out of an environmental board case back in the 1980s. Impact of growth, criterion 9, again includes a number of different issues. There's sort of, most of them are more kind of, I would say, statewide, state level type of concerns, such as climax soils, energy conservation, public investments, and then the new criterion 9L settlement patterns. Used to be called rural growth areas, but now criterion 9L is really focused on preventing sprawl. And so that's the criterion that we're now engaged in implementing, and we're working on additional guidance to provide the applicants on that criterion. And then the criterion is criterion 10, conforms with local and regional plans. The burden of proof under the criteria varies depending on the particular criterion. Criteria 1 through 4, the burden of proof is on the applicant, as well as criteria 9 and 10. For criteria 5 through 8, the burden of proof is on any opposing party. However, the applicant always has the burden of production and always have to provide sufficient evidence in order for the commission to make a finding on any of the criteria. And just to look at that sort of graphically, 9 through 4, the applicant has the burden of proof, 5 through 8 is any opposing party, and then 9 and 10 are the applicant. And that's it. Pretty quick and dirty, but again, we're happy to flesh out anything that is correct to address.
Thanks, Lou. That was an excellent summary. I think we'll wait for questions till after, and now I'm going to present Jeannie Oliver, my staff, to talk about Section 248. And the goal of this, obviously, is to be able to compare and contrast the two, because we often hear that people wish that some of the energy types would go in 250, and we're trying to see and understand the similarities and differences. So, Jeannie, welcome.
Thank you. So my name is Jeannie Oliver. I have met a lot of you, but some of you I don't know. I work in the Public Advocacy Division at the department with Jeff Commons, the Director of Public Advocacy. And I'm going to try my best to condense the 248 process down to 10 minutes. The last time I gave a presentation on the 248 process, it took approximately 2 hours. So this is
So
quite a challenge.
thanks. Could you pull the mic a little closer to you, just so the people in the back?
Sure.
Thank you.
And I'm going to run through what the 248 process is. I'll talk a little bit about the criteria that apply, but I won't spend a lot of time on this because I know that there are more presentations being given today that might address some of the criteria more fully. And then I'm going to run through the process, and I guess maybe one of the key differences between the Act 250 process and the 248 process is that we have a lot of different processes in 248, and it's a source of confusion for many people, especially pro se litigants. So I'm going to try and clarify it with a chart, and then at the end there'll be an opportunity for questions. So just a very brief overview of what the Section 248 process is well, it's the things that are exempt by Act 250. It requires the board to issue a certificate of public good for energy infrastructure, gas, telecom, and water developments. And of course, in this context, we're focusing on solar as part of the energy infrastructure. And as part of the 248 process, the board considers 10 statutory criteria. And I think it's really important to point out that some of the environmental criteria, actually most of the environmental criteria from Act 250 are included in Section 248, but not all of them. And then it also includes some criteria that are additional to the Act 250 criteria, which really looks at statewide interests like need, reliability, economic benefit, and the general public good. I've attempted to illustrate the different parties that are involved in a Section 248 process. Just a disclaimer at the outset about the role of towns and municipalities. It's still not entirely clear to me, I think there's a difference of opinion that exists as to whether they have automatic party status or whether it really qualifies as intervention as of right. I think the way it's developing is they're being granted party status as of right, but through the intervention process. And I would advise towns that that would be the best practice, just to make sure that they are being given party status in these proceedings. So I guess the first point to note, and this is going to be telling most of you to suck eggs because it's pretty obvious to people who are involved in the process, but it's not obvious to people who are outside of this environment, that the Public Service Board and the Public Service Department are not the same entity. The Public Service Department is a statutory party. We appear before the board, and we represent the state's public interest. The Public Service Board is the decision maker. So we're separate entities, and we do quite a different function. So I'm not sure if this table requires any more explanation, but there it is. And so I want to focus a little bit on the public interest because this is a source of contention. It seems when you represent the public interest, every sector of the public is a little dissatisfied with how you're representing the public interest. I have to emphasize that both the board's and the department's role is concerned with the state's public interest and not, for example, local interest or an individual member of the public's interest. And it's a really difficult balancing exercise because the public interest would look like a perfect Venn diagram. There would be a very clear center where everyone's interests are aligned. But of course, in reality, it's not a perfect Venn diagram. There are lots of different interests that need to be represented. Developers and adjoining landowners are often in conflict, not always, as just one example, and our job is to try and balance those based on the 248 criteria. So just to recap the 248 criteria generally, as I said, there's 10 statutory criteria, which include most of the environmental criteria, plus a number of others. I'm going to talk very briefly about 3 of the other criteria that apply, because they seem to be the ones that are most relevant to solar siting, and those are orderly development, aesthetics, and system stability and reliability. Sorry, I've got a dry mouth from being nervous. And just to point out before I go into these criteria that for some smaller projects, some of the criteria are conditionally waived, and that's most notably in net metering projects and in some renewable energy projects up to 2.2 megawatts. What that means when it's conditionally waived is that someone can still raise these as a concern, but the petitioner isn't required to produce evidence of these criteria at the outset. And if you want more detail on it, these slides are on the website, so I won't speak in detail on it. So orderly development is a criterion that we're going to hear a lot about in the Solar Siting Task Force, because this is one of the 2 criteria where towns and municipal bodies have their right to participate most clearly. And I've just set out the language of the criterion up there and underlined the concepts which are maybe controversial or a little ambiguous. So the board is required to give due consideration to the recommendations made by municipal and regional planning commissions, and also to the land conservation measures contained in the plan. And I've just set out 3 challenges. I know there are more than 3 challenges, but these seem to be the challenges that I care about most often in my role. One of those is that, during the comment periods, which I'll go into in more detail in this presentation, there's just not enough time for these, for the planning commissions to meet and caucus and discuss the projects, and then to, issue an opinion on it. So that's a real challenge for them. The other issue, which we've already heard quite a lot about, is that town plans, are generally not specific enough for it to give good guidance to the board. And that's something that towns are dealing with now and trying to change their town plans. And the other issue, and this is a very clear contrast to the Act 250 context, is that the local zoning regulations and bylaws are not taken into account as they are in Act 250. There's, it's much more an emphasis on state interest than local interest in this process. And I've just added a slide here on Act 56, which inserted some language about screening ordinances. I've seen so far at least one town who has enacted these. That was the town of Cornwall. I expect many more will follow, so it'll be really interesting to see how the board takes these into consideration and what effect they have. Probably the most controversial criteria that I deal with in my role at the department is aesthetics. It's a very passion-driven criterion, and I think that's because there's like a fundamental human side to the connection with land, and I think that's true both for renewable energy developers and for members of the public. They come in sort of from the same place, wanting to preserve land and preserve it, what's important. So this is, it's governed by the Queechy test, as we pointed out. It's a slightly different Queechy test to the Act 250 Queechy test, and I know that this has had a lot of attention in the recent years. The first step is saying, it's asking, is the aesthetic impact adverse? And the question there is really whether it's, thank you, character with its surroundings. I know I must sound really nervous when people bring me lots of water. But then it kind of diverges from the Act 250 review in the second part of the Queechy test when the board looks at whether an adverse impact is unduly adverse. And where it's diverted is in the third part of the second test as to whether the impact is shocking and offensive and the board's interpretation of the average person. And I think this has already been spoken about in the solar siting task force. So I won't go into it. I don't know where the board's going to go with this in the future, so I can't really express an opinion on that. But I've underlined in the 3 factors in the second part of the Queechy test where the controversy currently is, or what I see to be the controversy. The first is the clear written community standards. Again, there's been issues about town plans not being specific enough. They really need to be addressed at this particular type of land in this particular area rather than we want to protect the scenic nature of our town generally. And so towns are now working towards making their town plans more specific, and it's a challenge for them, which I'm sure we're going to hear about throughout the solar siting task force and hopefully be able to come up with some solutions for them. The second factor is whether the developer has taken generally available mitigating steps which a reasonable person would take to improve the harmony of the project with its surroundings. This is controversial for 2 reasons. The first, from the concept of adjoining property owners, it's not about making the development invisible, it's about harmonizing it. And I think that there's really a broad range of opinions on what that means. And so that's a real challenge for the board and for people participating in this process. And I guess the second issue is just how much of a consideration are adjoining property owners. The board in a recent decision said that they are relevant, but it's not they're not a determinative factor. So yes, they must be taken into account, but it's still it's still playing out in front of the board as to just what how much emphasis to give that. And then I guess finally, just a key difference between Act 250 and 248 with the Queechy test is that the Section 248 Queechy test is significantly informed by the overall societal benefits of the project. Now this one, it's not exactly controversial, system stability and reliability. I just wanted to flag it because in the last couple of months I've seen more instances of the utility saying that a project could not be safely interconnected because of the flicker effect. So I just wanted to make sure that's on everyone's radar.
No. Sorry.
Hi, this is Karen Horn. Can I just listen in for a bit?
Yes, of course you may. Right now, Jeannie Oliver is presenting a description of 248. Okay.
Thank you so much.
Thanks, Karen.
Sorry, Jeannie, I just missed the last thing you said as the phone.
That's okay. So I was just saying that this criterion has typically not been very controversial, but in the last couple of months we've seen a number of projects where the utility has filed comments recommending that the CPG be denied or that the project be scaled back to a smaller capacity because it was likely to have voltage flicker effects. And we're seeing that more often. So we weren't seeing that at all for a long time, and now that's occurring quite regularly. So it's something to just to keep in mind. So I'm going to move on to the process, and this is my attempt to summarize all the processes that apply to Section 248 hearings and proceedings. And I've set it out from the least process to the most process. The least process, of course, applies to net metering, where the board has made rules according to its statutory authority to enact expedited expedited processes for these types of facilities. And then between the net metering processes and the full Section 248 process, there's actually two sort of intermediate size processes. The 248J, that's a limited size and scope project, and then for renewables up to 2.2 megawatts. And I have a few slides that just set out the detail of those processes. I'm not going to go into it, but if you would like to look at this, it is on the website. Especially for the net metering, because there are so many different rules that apply depending on the size of the project. And again, this is where it's different to Act 250. The first determining factor for the process is the size of the project, and not the issues raised on the assumption that smaller projects raise less issues, which is often true, but not always. So the lease process goes to solar systems less than 15 kilowatts, and then the next stage is 150, then 500, and then larger than 500. And the difference between these processes is really about the notice period and comment period. When you have a project that's 150 kilowatts or less, there's no 45 pre-application notice period. And for rooftop systems, it's a 10-day comment period. For ground-mounted systems, it's a 30-day comment period. And the parties that receive notice are a little bit different than with larger systems. With the systems between 150 and 500 kilowatts, there is a 45-day pre-filing notice period. The idea behind that is that the developer can reach out to the community and try and resolve design issues or perhaps aesthetic issues before filing their petition, which would hopefully reduce the amount of process required in front of the board. And then after the petition is actually filed, there's a 21-day comment period. This is an interesting issue that's been coming up with the special net metering projects. So these are projects that are greater than 500 kilowatts that have statutory authority. Those actually do not have an expedited review process that specifically applies under the board's rules. And those have been proceeding under the normal 248 process. So one of those is the 248J process. This process is a little problematic in that the board's rules and the statutes don't actually clarify what limited size and scope means. To date, the largest facility that has been authorized under this section, to my knowledge, is 1.5 megawatts. And yeah, it's unclear to me what the limits are. That's an expedited process. The board will issue notice to the parties that are entitled to receive a copy of a petition under section 248A, 4, and C. And then there are 28 days to comment on that project. This is a slightly obscure, not well-known provision. It's an order that was issued by the board under its authority in section 8007B, and it provides potentially an expedited process for renewable energy projects up to 2.2 megawatts, but it's not automatic. The petitioner has to show grounds for getting a different process and notice requirements. The real benefit to falling within this provision is that there are some conditionally waived criteria, so the burden is lower for the petitioner at the outset. And then this is the full section 248 process, which is considerably longer than any of the other processes I've just outlined. It generally takes between 5 and 9 months to complete. It starts with pre-filing requirements. There's public hearings, site visits, discovery, evidentiary hearing, legal briefs. It really is a formal process, and I think this is the process where pro se litigants feel the most out of their depth, because it very much looks like a court process, unlike the other 248 processes. And I guess a key difference I should point out between the Act 250 process and this 248 process is that there are no statutory time periods given for issuing a decision. And, yeah, so that I know will be criticized. This is just pointing out the notice requirements for the 248 review. And that's all I have. That was pretty fast.
Great, not bad. You both did really well. First time, it should have really taken about 2 years to explain for everybody. Thanks.
We're holding a question.
Now we're going to go into questions and comments, because thanks, Lou and Jean.
Can I nominate Anne to answer questions on my behalf?
I'm sure she'll be pleased to do that. Thanks, both of you. One quick clarifying question that I have, and then I'll turn over to my other panelists. But Lou, you mentioned communication towers over 50 feet are regulated under 250, and yet we have the 248A process for telecommunications. Are they overlapping, or is there a clear distinction?
It's actually the choice of the applicant.
Okay.
We actually do still receive applications for telecommunications facilities. There's no, not either or, well, it is either or at the moment. Applicants can choose to go through Act 250, or they can choose to go through the 248A process.
Okay, but they can do one or the other, but they don't have to do both.
Right.
Okay, thanks. Yeah, that's helpful. And then one for G. So the full 248 review, which requires discovery, it really is a court-like proceeding, right? With, you know, discovery and cross-examination and blah, blah, blah. You know, it's really participating in a couple of them myself, I would say, more painful than the other processes. But that said, do you feel like, do pro-state people feel like they can do the other processes well, or do they have similar difficulties in the 248J and the 248A and the smaller scale
Right.
processes?
I think there are difficulties in all of the processes. I think one of the key problems at the moment, which we're hoping will be corrected through the Act 99 net metering review process, is that it can be difficult to find all the information that a pro se litigant might need to understand how to participate in any of the processes that I've outlined. So definitely there are difficulties with all of them.
Okay. And my last question of both of you, or either of you, and just, can either of you summarize real quickly the environmental criteria that are in 250 that are not in 248?
Annie's our expert on the 248 versus 250 because she works in both. But, so wait, 6.
Probably it's easier just to read the ones that are, because everybody in the statute, I think they.
Okay, whichever way they say.
We don't really think of it in that way.
Yeah.
Yeah.
Well, I think a lot of people do, and if you don't, that's...
No, we don't, because we do what we do, and we don't.
Yeah. No, I get it. So, and we feel like, from the department standpoint, we feel like the board has authority to include, if not in the specific criteria, then within the general public good evaluation, we can broaden their concerns into consideration. But I wanted to know, just so everybody was on the same page about what specifically was and wasn't overlapping. Or is that a bad question?
That's a good question.
Annie's about to answer this for us if we don't.
So, 248 includes the Act 250 criteria in quotes. So it's 6086, A1 through 8 and 9K, as well as greenhouse gas impacts, as well as 10 VSA sections 1.24AD, which is outstanding resource waters. So, do you want to go through? So it will include basically undue air and water pollution is number 1. Number 2 is sufficient water available for the reasonably foreseeable needs of the subdivision or development. Will not cause unreasonable burden on existing water supply. Will not cause unreasonable soil erosion or reduction in capacity of soil and water, etc. Will not cause unreasonable congestion or unsafe conditions with respect to use of highways. No unreasonable burden on educational services, local government services, and 8 is scenic and natural beauty of the area, aesthetics, historic sites, or rare and irreplaceable natural areas. So then you get into 9, which is where the differences really are. So it's specifically only 9K that is included. So 9K is development affecting public investments. For the other parts of 9 that are specifically not included are impact growth, primary agricultural soils, productive forest soils, earth resources, extraction of earth resources, energy conservation, private utility services, cost of scattered development, public utility services, and settlement patterns. So those are the ones that I just read that are not transferred over.
Thanks, that's probably.
Just on this slide that's up here about the process and the full 48 process and what's involved, it's just important to note that our permits are subject to a full de novo review in environmental court. And so while the quasi-judicial review that the commission provides vary depending upon the size and scope of the project and the participants, although you could have cross-examination, you could have, fairly formal type proceedings at commissions, that's generally not the typical Act 250 process, but they, on appeals to environmental court, it's court, and it's de novo review for whatever the issues are, and the rules of evidence, and the rules of procedure, and discovery, and all of that. So I just wanted to
Thank you.
That's an important distinction because with the Section 248 process, the review is to the Supreme Court and it's on the record.
So the main difference being that because your Act 250 wasn't evidentiarily structured like this.
Well, I think it's different. It's a permit versus a certificate. It's a different type of decision.
Yeah.
It's a permit decision like a local permit decision or an agency of natural resource permit decision, and subject to a different sort of appeals process.
Yeah. Whereas the 248 process, it goes through the court. For a layperson, let me say it this way, you're going through a more court-like process during the process, so the court can consider an appeal on the record as opposed to having to do it from scratch.
Task force members, questions?
Hi, Jeannie, how are you?
Good things.
Actually, these are sort of clarifications, and just wanted to touch on a few things. You mentioned the issue of intervention and party status at the beginning, and maybe I may have missed this, but I think, as you know, Act 56 changed that with respect to municipalities.
Right.
So that now I think it's fair to say municipalities do have automatic party status.
It's a little unclear, and I think the board is not totally clear on it yet either. The language of Act 56 says it's the right to appear as a party as opposed to shall appear as a party, which is the language used with respect to A&R who has statutory party status. I know that what towns have been doing, and I think it's probably just the safe option, is making sure they file a notice with the board saying we're exercising our right to appear as a party, just in case they get voted off. So it's a little, I think the intent was for it to be automatic party status, but I'm not certain that that's how it's playing out. And just to be safe,
But is there, I guess the real question is it a sort of distinction without difference in the sense?
Perhaps, yes.
In the sense that towns don't have to demonstrate anything other than, here we are,
Correct.
we want to participate.
Correct. They just have to say, we have a right to participate and we want to participate. What I don't know the answer to is if they don't notify the board that they wish to participate and they want to appeal the decision, whether they had party status to do that. I'm not sure what the answer is to that.
What's the other issue that's sort of interesting in your presentation is the differences in how PG has been used in Act 250 versus Section 248. And what I've seen lately is that the board has gone to great lengths to say two things. On the one hand, that it does believe, because it's issuing a certificate of public good, that it should look at public vantage points of the project when looking at the question of what's shocking and offensive to the average person. But in recent cases, they've also said clearly, we consider the effects to not just to joiners, but to neighbors generally in the context of what is generally available mitigating steps that need to be taken. So I've seen them try to make clear that they are considering the private views, but they're doing it in that part of Queechee rather than the shopping and events part of
I
Queechee.
think that's the correct observation, and I really think the generally available mitigating steps it's about the context of the project. So where a project may have a residential context, I think the board is more likely to look for evidence related to impacts to adjoining property owners or to neighbours than if the project were in, say, a commercial or industrial context. The shocking and offensive factor isn't as clear that it's about the context of the project without mitigation. So I just think it's easier to put the impacts to adjoining property owners in that second factor.
With regard to the last one, the other one that's different from Act 250, how is that applied in Public Service Board? Does that override undue adversity? Or
I've actually
a separate consideration?
I don't think it's separate. It goes to whether something is unduly adverse. But I've not seen in any recent decisions the board actually rely on that factor.
Can I just add something?
Yeah.
Because it is rarely used, I agree. The case that I can think of where that was discussed was the original Searsburg Wind Project. So 1997, the first wind project in Vermont, really. And what the board said is they do Queechee first, and then that is an overlay. It's not within Queechee that they have done that analysis. So they didn't find undue adversity in Searsburg, but they did say our...
Yes, Sam?
Did I understand that the Act 250 process does not have, or any, I guess let me put it this way, what does the Act 250 process consider a statewide interest at all, or how would it, if it were, do they enter into this?
For the aesthetics analysis?
No, for the overall permitting.
No, it's not a public, so it's a permit. I think a fundamental difference between the Act 250 and Section 248 is it's a permit. You need permission to build. You have to meet all the 10 criteria and the sub-criteria. You need positive findings on each and every one. It's not balanced out with anything. Where the burden, like as Lou indicated, the applicant has a burden on most of the criteria. They have to prove that they meet the criteria, and if they don't, they can't get a permit.
It's very much a site-specific review, and I guess there would be a couple of exceptions to that. Traffic might be one where there can be pretty significant off-site impacts on traffic. But by and large, for most of the criteria, you're really focused on the site itself and the impacts of the project on that site.
So statewide, just to clarify for Sam's point, statewide planning of any kind, be it energy plan or if we have land use plan.
It's relevant evidence. I mean, for some of the growth criteria, for example, if you're in a designated growth area, you can help you meet that criteria if evidence is meeting town and regional plan. But it doesn't get balanced. It's really you look at the evidence. Our training to the commissions is take the evidence. You have to be convinced that all the criteria are met. You don't get to say, well, this one's not met fully, but there are other benefits, so we'll accept 3/4 of the way. That's not part of the process.
I think one of the big differences that you noted is that in Act 250, there's criterion 10, which provides some plan context to those decisions. That was another criterion that didn't get taken over in the Public Service Board, probably because the orderly development provision was already in there. But they are given different weight and different meaning in those respective processes. They aren't the same at all. So.
I didn't understand what you just said. Could you just...
Well, and you guys can maybe explain this better than I can, but under Act 250, there's criterion 10, which says a project has to conform to the local and regional plan. So it does look at the plan, and if the plan's not clear, they'll actually look at zoning regulations to see, to make sure that what's being proposed is consistent with the plans. In Section 248, as Jeannie explained, there's an orderly provisions, and also the recommendations of local and regional planning commissions and municipalities. But it's a little bit more narrowly applied in that
And the
context.
language is due consideration, not conformance.
And with
Go ahead, Sam.
with respect to that, one of the issues in the background that we're trying to process through this is what level of specificity that Act 250 requires for, and we've heard that the applicants, municipalities object to the citing under 248, that the board is holding it to having specific, as opposed to broad general admonition to be supported. Something.
That's the same.
Act 250 get into that in a more
That's-
specific way?
Statute 50 works the same way in that regard. You need specific language. And as Sharon was saying, you can look at zoning to try to see, what the plan is saying and interpret it. But our advice for years has been to towns and sort of our regional planning commissions is that you really have something important in your plan and you want to have as much weight in Act 50, be specific. Be really clear. If it's broad and general, then it likely will not be able to address the impacts of the project directly. If you're really concerned about something, be specific. I think the PSP is work the same way in that regard.
There's also quite a bit of case law on the Act 250 side regarding those interpretations of plans and how specific things can be defined. I think one of the big question marks we have now on the 248 side is a recent decision which says that if it's so specific that it looks like zoning, it's de facto zoning, and therefore it won't be considered.
You can go too far.
And
have a problem.
The no good deed goes unpunished side, yeah.
exactly, we're still trying to figure out how to get around to that now.
Oh,
Yeah, that we haven't had that would be interesting for us because that would be contrary to some of the, we've been encouraging towns to be specific and regions if you really want to achieve a certain result for your planning documents.
So, I think we need to move on, but I don't want to cut our folks off. So any other questions here from folks? Okay. I'm going to give one other observation. You guys can correct me if I'm wrong, but I see under the nine subset criteria that some of them are not included in 248 that are in 250. I think because like utilities and things like that, because we have other, maybe this is along the lines of what Sharon was describing, we have other areas where those are covered, such as, reliability and overall things. And so I don't think, it's not an exact matchup, but it's interesting to see how these are played out in different places.
I'm sorry, just to make one other observation. I think the fundamental difference between Act 250 and 248 is this issue that we're talking about on the town regional plans under criterion 10 versus due consideration. That's true for all the criteria. That is, Act 250, if you don't comply with any given criteria, you don't get a permit. It's effectively, you're done. The board, by statute, is tasked with determining what's in the public good. And the board balances all the criteria that it has before it. So it's not as if there's a on-off switch the way there is in Act 250. I think that's a fundamental difference. And Shannon should point out, under criterion 10, it is, do you comply with the town plan, don't you? B1 is due consideration with town regional plans. But I think that's in keeping with the fundamental difference between what the board is required to do under the statute to determine public good and what Act 250 is required to do under the statute to issue a permit that shows that you comply with each specific criteria.
All right, any other?
I'd like to say something. To speak to that a little bit, the reason for that was with transmission lines, or at least one of the reasons for that was with transmission lines, they had to go through multiple towns, especially transmission lines or big old generation plants, like you think about it. They had more than impact on one town. And while there's certainly a policy impact statewide for solar, facilities. That's not necessarily the case, so I think it's something that we will have to consider.
Yep, okay, fair enough.
Chris, and maybe as we hear from more folks, I'm still trying to get my head around what the participation ability is for the average citizen and town in the 248 versus the 250 process.
Well, okay, I'm going to say, and again, feel free to jump in, but I think to get to the core of it is that if you want to participate in the 250 process, you can show up. If you have a particularized interest as a general person, right, you've got other categories there that can participate. But if you've got a particularized interest, you can just say what you want, what you feel. You can tell the commission in an informal way, this is what I think is happening. Now they can weigh that and decide the amount of weight to give that. Right? But in the 248 process, a similar adjacent property owner or someone who would be a party, could get party status and intervene, would then be subject. They can't just say, I think that this is a problem for X, Y, and Z without being able to support it. They would have discovery questions issued on them. They would have cross-examination. And then, the board would give the appropriate weight to it, but you'd be tortured through that process. I think it's fair to say for the average person, that's a little more daunting.
Just to clarify, though, I want to be really clear about this. So, anybody, if you get party status, which is really your question, Robert, is how difficult it is. And, the particularized interest standard, as you know, when the law was changed, it used to be easier in Act 50 to get party status. It used to be you could assist the commission, you could get party status, which changed in 2004 that you had to have a particularized interest, which really mirrors standing. It's a legal standing. It's really a lot, just like you go to court. So it's not meant to be a high bar, as Lou indicated, but it's meant to weed out people who really have just a general concern, or if you live in Brattleboro and you have a concern about a project in St. Johnsbury, you seemingly have no other connection to what's going on, you will not be able to probably prove that you have a particularized interest. But usually the people who show up are people who live in the area, have, a interest that is directly affected, and then you could get party status. Once you get party status, you could say what you want, but if it's not backed up with evidence, the 10 criteria, as Lou put up there, they're not for the faint of heart. They're technical, scientific, air and water criteria, or planning criteria, or traffic criteria. So you need evidence, just like in 248. If you don't have evidence, you're not going to be successful. And then, if you get to say what you want to say, and you don't like the decision, you got to go to court. You actually have to go to court with your appeal, and then it's discovery, it's depositions, and it's the whole 9 yards, if you want to proceed forward with whatever your concern is. So I just want to be really clear that, Act 250 is an administrative law process that is based on evidence and the law and facts and science, and if you don't have good arguments in that regard, you're not going to be successful.
Just Bill, you want to?
I just want to clarify one thing also.
Bill, you pass it.
Thank you. To your question, Robert, recall that the vast majority of solar projects being proposed in the state right now are net meter and group net meter. They're not going through the 248 process where you need to seek status, become a party, and provide testimony. A citizen would have a 21-day period after a petition is filed to write a comment letter to the board where they have to identify if the project raises substantive issues under the criteria, provide some level of justification for that, and propose ways to mitigate those impacts or request a hearing. So they have to kind of figure out how to engage through that comment process in short order to influence the decision of the board on most of the projects that people are seeing in their communities.
Yeah, so just to clarify, because I think this is an issue that many people struggle with, is a member of the public has several options when they see a petition. They can just file comments, which don't become part of the evidentiary record, but the board does read them and it may inform their line of inquiry. So I always encourage members of the public to file comments if they feel strongly about the project. The second option they have is to file a motion to intervene to try and get party status. So there really are the two different avenues that they can pursue. One is a more formal process that they will engage in, and the other is less formal.
And I'm going to just add one other piece to that, just so people are clear, and then I promise we'll move on, because I'm doing a great job of getting us woefully behind. But the purpose of the 45-day notice is also to give a less formal opportunity for people to be aware of projects and resolve them. As I have personally done on adjacent property that had a cell tower, I took the 45-day notice to ask questions of my neighbor and of the applicant, got the answers I needed, got some resolution to a couple of issues I had, and I didn't need to participate in it. And so, that's what that purpose, that's what that is for, and we should, be making use of that. Okay, with that, I think we're going to go on, and Sharon's going to help us with Chapter 117 on the relationship with land use goals and energy goals, and then we're going to have a couple of other discussion points, and experiences to date, and then open it up for public comments. Lou and John, thanks. You, of course, are welcome to stay.
And you said you're welcome to stay.
Thanks very much, guys.
Let us know if there are any other questions about activity.
Oh, I think we will reach out to you. Thanks.
Trying to pull up, I just wanted to point out on the task force materials tab of the Solar Siting Task Force website, there's a comparison, section 248 and Act 250 that Aaron Adler made for House and Senate Natural Resources and Energy Committees that lays everything out side by side as best as possible for criteria and process and all of that. So it's very helpful to review if you haven't.
Thank you.
I was away when Ann's request came in, so I didn't have much time to put this together. I will apologize in advance that it's very wordy, very plain vanilla, no pictures, no interesting things. I promise I won't read stuff literally, but in terms of going through it, I'm just going to highlight some things and then make this available as a reference document for later. I will also say I'm a planner, I'm not an attorney. Adam's both, an attorney and a planner. So we tend to look at statutes a little bit differently than lawyers do sometimes. But my presentation is basically on the Vermont Planning and Development Act. It's the Bible that's used by the planning community. It's supposed to be referenced by local and regional planning entities, but also state agency planning. There's some things in there that apply to that as well.
Sharon, while you're teeing this up, I don't want to interrupt you as we go, but just to note, my fault, but we're about 15 minutes behind schedule.
Okay.
So I say you have about 10 minutes of presentation, if that's okay.
Okay, I'll try to,
So,
and I haven't had a chance to time this, so if it comes to the end, just cut me off.
well, we can also revisit stuff as we go.
Yeah.
Thanks.
And again, this was also prepared for another presentation, so I just pulled some things out. Historical timeline, planning, and regulation of energy facilities has been going on for a long time. And I've been doing this for 30 years, so I don't quite go back to 1908. But again, the Public Service Board was created back then, and there is a provision in Title 30 that even back in that day, that if any municipal authority to regulate or to approve stuff, so it's under the supervision of the Public Service Board. Planning and zoning as it exists today started in the 20s and 30s in Vermont. So it's been around for quite a while. Most communities didn't start regulating land use until the 70s. But the one thing I did want to note was between 67 and 70, some of you maybe remember that was when there was a lot of excitement, a lot of initiative at the federal and the state level around planning for our future, planning for infrastructure, planning for just our development in general. And the Planning and Development Act, the Section 248 and Act 250 were all enacted within a few years of each other. And I will say they're all good statutes, they've all held up well since then, but they've all kind of created this sort of tension or confusion regarding who should be doing what when and how things are regulated over time. But again, our statutes date from 1967. And during the last energy crisis in the early 70s, or the late 70s, there were a bunch of energy provisions stuck into the planning and development statutes. In 81, the state energy planning requirements came into effect. In 87, we had a major overhaul of the plan, and all of our statutes, and it was basically the Growth Act of Act 200, and we still hear Act 200, but it's starting to fade away at this point. But anyway, Act 200 tried to create this fairly complicated framework of coordinated local, regional, and state agency planning. And parts of that have worked over the years. Local and regional planning have improved significantly. Parts haven't. Part of that hasn't has been that coordination function. But again, Act 200 also established state land use planning goals, just as we have energy goals we're working with under the energy statutes. We have state land use goals that are applied to local, regional, and state agency planning that are under this section of statute. Then there's been a lot of stuff going on recently, both on the planning side of things and the energy siting things. A lot of that came together in the Siting Commission report in 2013. And then most recently, the stuff Jeannie mentioned with regard to 248. So I'm just going to try to go through this quickly. And again, this is a walkthrough of 117. It's broken up into basically a few major sections. The first are the state planning goals that were adopted back in 1988. The second are defining the roles and responsibilities of everybody for planning. And in this case, the Housing and Community Affairs is our lead agency. The creation of regional planning commissions, we have 11 of those. Municipalities in terms of how they plan, for legislative bodies, planning commissions, and then how they also regulate development. Key for this group are municipal and regional planning requirements, which we'll go through in a bit, and then how plans are actually implemented. Commonly, we all reference zoning and subdivision regulations, things like that, but one of the ways plans are implemented is through local and regional participation in Act 250 and Section 248. Again, going back to the state planning goals, there's this general purpose to encourage appropriate development, and actually, it's interesting, this kind of mirrors the orderly development in Section 248. All of that language actually dates from the 1920s in the original standard planning acts that were issued by the federal government. I think that's the first time orderly development of the region was used in a formal capacity. But you see it all over the place now, all over the country. There's basically 18 planning goals. There's a lot of sub-goals, but there are 4 state planning goals that relate to process. And in this case, my major point in this is that planning is not permitting. And citing considerations, and I appreciate the fact that Chris mentioned this in our first meeting, that citing actually is not permitting. And citing considerations, and I appreciate the fact that Chris mentioned this in our first meeting, that citing actually can't really be addressed within a permitting process. It has to be addressed in advance. Right now that's being done between the developer and the landowner. In the best of worlds, it would also involve, those kind of discussions would also involve the community again in advance of the permitting process. The planning process, as opposed to what we've heard about 248 and 250, is supposed to be very inclusive. And it's supposed to be coordinated again at this local, state, and regional level. statewide interest is number 2, that says that decisions should be made at the most local level possible, commensurate with their impact. So I think Adam raised that question sort of indirectly, that some of the development, the energy development that's happening now, including putting a solar panel on a house, is very local versus potentially of statewide significance. So that's one issue that's come up in our discussions. But then again, you look at number 3, where it says that the use of resources and the consequences of growth, you have to consider those for the region and the state as well as the local community. So it goes down in terms of how decisions are made, but it also says municipalities have to look not just at what's happening in your community, but what's happening in the region and the state. There are 14 planning goals. Again, I'm not going to list them all. You can go to statute. I just pulled out some that are specific to the siting discussion. The main one, and this is a mantra in the planning community, that we're planning development to maintain a historic settlement pattern of compact villages and urban centers separated by rural countryside. And again, it's kind of a 19th century landscape that we're trying to bring into the 21st century. Not quite sure how to do that, but that is, again, one of the key goals that's out there, one of the standards. We talked about energy efficient transportation, identifying important natural features and historic features for conservation and protection in the landscape, looking at Act 250 considerations in the local and regional planning process, and actually those criteria are mentioned in several sections of our statute. And then also, and the key one here is to encourage the efficient use of energy and the development of renewable energy resources. And again, when you're drafting plans that are supposed to conform to these goals, you're dealing with a lot of them. And when people say we want to be specific, that's good, but the point of a comprehensive plan is to also see how these things interrelate. So we do get plans that say we want to protect our ridge lines and we want to support renewable energy. And the problem is, how do you reconcile those two things when they're in conflict? We also have statutory definitions that control what we do in plans and in our regulations. Land development is defined differently at the local level and the regional level than it is in Act 250 and 248. It's pretty inclusive. It even includes a subdivision of land. Renewable energy resources, this was defined in our statutes, I think back in the 70s. It might have been updated. I'm not sure it's consistent with the current definitions of renewable energy in Title 30. And getting to your point, should is actually defined in statute. So wherever you say should in your plans or your bylaws, it means it's something that you're recommending, but not necessarily something that you're requiring. And that should-shall discussion comes up quite a bit in terms of how we draft plans, specifically policies for consideration in 248 and 250. I will say municipalities are not required to have plans, they're not required to have planning commissions, they're not required to have zoning bylaws. It's optional in Vermont. But if you do have a planning commission, they can do all kinds of things. Obviously, their most important task is to develop a town plan or municipal plan, but it's also bylaws and amendments and other codes that may not be adopted under 117. But again, there was language added in 79 about also looking at energy and renewable energy resources, just as a general duty of a planning commission. Regional, and maybe you guys know the history in this language, because when I was going back through, this was sort of a surprise. It's actually in the optional powers of a regional planning commission. Number 1 specifically says to work with everybody to propose and evaluate alternate sites for distributed power facilities that might provide uninterrupted local or regional power. This was apparently added in 2005 under the radar. Again, I'm not sure what the context for that was, but that kind of gets to the point of what's been recommended in the siting commission and some of the things we've already started to talk about. And again, making recommendations as the same provision that was in the municipal in terms of renewable energy. But the RPCs, unlike municipalities, also have mandatory requirements that they're supposed to do. And one of them is aid in making determinations under 248, which is interesting because they don't have party status. But they are required in our statutes to appear. And again, that same language to be given due consideration where relevant. Regional plans are also supposed to include the definitions of substantial regional impact, and I'll get more into that in a minute. But it's used with respect to its region. So again, something that's substantially regional impact in one region may not be in the other, or something that's supposed to be defined under the regional plan, based on the context of what's going on. Municipal plans, again, for planning purposes, this includes towns, cities, and incorporated villages. Again, colleagues aren't required to plan, but I suspect 90-some% do. A lot of them, most do now. Again, these are prepared by volunteer boards with some assistance, but they usually meet once a month. They don't have a lot of staff and a lot of resources. There's, again, community outreach is required. They have to be readopted every 5 years to remain in effect. And they are the basis for, again, participation in 248, 250, and also for local regulations. Regional plan is the general purpose. One of it is to guide reasonable use of renewable energy resources. Again, these have to be consistent with state goals, include required elements, and they have to be adopted every 8 years. Why that 8-year came into effect versus 5 years, we don't know, but there it is. And again, they also have to be in effect to be considered. There are 12 plan elements now. We've added a few over the years. The ones in red are highlighted specifically for consideration in this context. There's a land use plan, again, that provides the basis for zoning at the local level. Utility and facility plans and maps are supposed to show, and well, we'll get into more of that, but again, the energy plan, and then the newest one is a flood resilience plan. Energy issues may come up in other things like transportation, housing, economic development, but these are the key ones that are usually discussed in. Land use element doesn't really talk about energy or infrastructure. And it does require a map and where things are located. And again, this is supposed to provide the context for zoning. It also, in Act 250, provides a context under criteria 10 where again, siting should occur, where those siting decisions are being made in the absence of having a state land use plan in the case of Act 250. Utility and facility element of a plan is supposed to include a map that also shows proposed generation plants and transmission lines, and existing and proposed. So there is some requirement for looking ahead in that respect and looking at what's going on the ground. And then the energy element, which you think would be most relevant, but is most ignored in this. In part because I will admit, energy elements of plans have been very weak for many years, and mostly because there's a real lack of information at the scale needed to do that kind of planning at the local and regional level. That's why we're really interested in the department's regional planning pilot project, because we're thinking that this might be a key to the way forward in terms of good siting decisions and discussions. This is actually in our statute. It's not in 248, but it does reference the fact that if there is a conflict between municipal recommendations and regional planning recommendations, how they're supposed to be addressed in those proceedings. I don't know if you guys have ever even looked at this stuff, but it's in there. And then there's a lot of ways to implement plans. Again, I'm not going to go through all of them, but at the local level, it's through zoning, subdivision, and site plan review, and in our case, participation in state regulatory proceedings. I will say that some of the conflict at the local level and confusion comes from our statutes, not yours. There's a very basic limitation that was enacted in 2003 that says, hey, if it's regulated by the Public Service Board, you can't regulate it under your local bylaws adopted under 117. Prior to 2003, it actually was some limited regulation of public power plants and transmission lines. But there was this case back in 1975, South Burlington versus Belleville, I think, of over a transmission line, as Adam said, where they really tried to clarify and limit what municipalities could do. But if you look at local bylaws, most of them predate 2003. There's a lot of language in there about regulating utilities because it was the understanding up until then that you could. And even after net metering came into effect, communities were regulating net metered facilities, not clearly realizing that they were covered under certificates of public good. Because Vermont, we know, is the only state that really exempts that level of facility development from local regulation. Most states you can regulate, say, solar installations on a roof of a house. So there's some tension over that, and I will say it's interesting because a lot of it's been aesthetic and big things, but in terms of the planning world, there's been quite a bit of tension on how the 15 kilowatts are cited without any basic level of review in relation to flood hazard areas, road rights of way, on historic structures and things like that. I don't know if the task force will extend into that minutia in terms of how things are cited and regulated, but it has raised some concerns. Then we get this goofy stuff in our statutes. We can't really regulate them. We actually can regulate things that aren't hooked into the grid, and that's the difference. If it's not on the grid, we can still regulate them. So we start getting things like this. And again, I don't know exactly where this stuff came out of, but it's very specific to solar panels on slope roofs of less than or equal to 5%. In this case, it's not quite that. I will say, though, the one thing that we're all missing the boat on is there's stuff in 117 that actually supports planning and design and regulation around incentives for promoting renewable energy. And I will also say that we're actually have the only statute in 117 that actually looks at solar access in terms of defining setbacks or other things that will actually provide solar access. We don't have good access easement laws in Vermont. This was added, I think, again, back in the 70s. And again, on the big things, big installations, may not even be so much of an issue, but in an urban environment, in a growth center, when you're looking at cutting down trees versus putting up solar panels, it does become an issue. And right now, there's no way to address that kind of tension. There's also a provision for basically, and I know at least two communities, Heinsberg and Underhill, that have updated their regs to allow for net metered subdivisions. So if you have a net metered subdivision where it's actually designed to be solar or wind ready, and you identify where and how both your developments can be located and where your solar panels and things are going to be included in that, they provide incentives for that. And that's actually occurring nationwide. There's a lot of impetus to provide those kind of design regulatory incentives for solar. We also have statutory review standards that date for many years. Under our subdivision bylaws, how land's subdivided to promote energy conservation and the use of renewable energy resources. Under site plan and conditional review, we're required to find whether a project will protect or not have an undue adverse impact on the use of renewable energy resources. And again, under plan unit development, there's provisions for how subdivisions are designed to incorporate renewable energy. So again, that's just a quick walkthrough of our statute.
Appreciate it very much. There's a lot of information there that will be on our website and available.
Yeah.
But that was very helpful. Thanks. Any quick questions from the panel? Again, we're still in the spirit of, okay, we're going to move right on to, this is sort of a start in a series of conversations we're going to have. We're going to hear from both concerned towns or residents about what their challenges have been in participating in this process, or what they've seen in terms of development of solar in particular, and then also kind of hear from the developers' point of view what their experiences have been. Let me, before I start, because again, we are about still 15 minutes behind, and I want to give public comment. Is there anyone who wouldn't be willing to or can't stay till 3:15 if I wanted to, if we needed to do that?
I can't because I have another meeting at 4 in Burlington.
Okay.
Soldier on.
Okay, we'll keep going. I may reserve the option of being able to go that far, but I won't go any further. I will not make a habit of that. But on this one, we're going to get that away from us. So, Peter Rothschild, hi Peter, is going to talk to us about the town experience and suggestions for solar development. As concise as you're able to be fair. Yeah, right. Thanks, Peter.
Okay. All right, Lydia?
Yeah.
Let me do that. This is a little preface. Give you some sense of context. I'll read a little bit of it. My thoughts on changes to state policy on renewable energy, and in particular PV solar, are based on my observations of how the solar rollout process has been working and my desire to see the state greenhouse gas emissions reduced and achieve the long-term goals of the state. So I am probably one of the few people that have these meetings who have really run right down the middle. I want to see solar done. And my background is the Planning Commission in New Haven, which is a thankless job with lots of pros and cons and fights from all sides, and sort of in the word of Bernie Sanders, enough of the bad emails, enough of the fights, trying to come up with some constructive thoughts and possibly new ways of looking at the issues that we have. Because I think the current policy clearly has created a lot of issues, otherwise this group would not be here. So why don't we, do they all have any printouts, or read that?
Yeah, we do have the printout in our packet, so we're good with that. So I would ask, try and summarize as best you can.
Absolutely, yes, so everybody can read. I think the key issue up top here, fairness of distributed energy, is that every citizen in the state bears a cost of greenhouse gas emissions, climate change, and so forth. And in my view, each citizen ought to also bear the cost of cleaning up the mess and going towards renewable energy. The issues that seem to be coming up are a combination of concentration of projects in particular areas, and we are like sort of called ground zero, so we have a lot of sense of that. And the other side is trying to match up to the goals of distributed energy. So I came up with this sort of idea, well, why don't we just compel every town, or it can be extended to a region. Let's have every town responsible for producing X amount of solar energy in proportion to its population as a percentage of whatever the state goal is. So it's 100 megs or 1 million megs, whatever. Each town would have a percentage of that. And in a way that does take care of the fairness issue, which is one of these things that's creating social strife. If you live where I do, there's no question that becomes an issue. How that matches up also with the desire to have distributed energy and have the source of the energy be closer to the use of the energy would seem that it is population based and would also accomplish that goal. Just without having to read every bit of it, once you compel the town to do that, you've now shifted the burden of execution from the state level and the state reviews to a large extent. You've thrown the problem right back to the town and said, you solve it. And my experience is, and listening to Sharon's comments, some of it sort of matches up. Is that some of these local issues could be best solved locally, and if the town of New Haven had an obligation to produce, or any town to produce, pick a number, 10 megawatts, let the town figure it out. We are actually rather much closer to the individuals in the town, and we can also sort of make it work, if you will. Somebody will say, well, they can't what happens if the town refuses? Well, I would almost look back to Affordable Care Act and say, hey, it's part of Obamacare is that everybody should be required to sign up, and if you don't, you pay. Well, there's a market mechanism that could be put in place. It's not simple, but it is a different way of looking at this and getting the process, in my view, out of the idea that the state is forcing towns to do things. Developers are evil. The PSB is the hand of the devil. I mean, I've heard it all, and it's non-functional. So I think move the problem solution to the towns, but make them be part of the solution rather than part of the problem. Currently, and in terms of writing town plans, my guess is that towns that have been impacted or see themselves about to be impacted with development are going to start writing town plans that are very defensive. And ultimately, it's going to make it, and it's a huge waste of human resources. Trust me, I've seen I'm part of that process and looking at it, and I was like, what a total waste of time. Because it will either be so specific, and then it'll come up, and somebody at PSP or somebody's going to say, well, this is, you did it with a purpose, and we'll throw it out, and the towns go crazy, and it becomes a useless waste of energy. So, why don't we go, so that's sort of the general framework. Some more specific things that add up. They're separable issues. No, back. I can find what I'm looking for. No worries. One of the issues that came up, and somebody mentioned it here, I can't remember whom, that there's an idea that smaller projects create smaller problems. It's not the case. And we are proof positive. I mean, this is no longer theoretical. We have 2.2 megawatt projects. We got 150s. The paradox is that the 150s create way more social problems than do the 2.2s. The reason, there are a couple of reasons, and what I would suggest is you make those 150s, or actually anything over 50 kW. I'll go through. I don't know. I'm not. This is not my world. Whether it's full 248, but they sure ought to go through a much more involved process for a couple of reasons. Number one, your town governments, planning commissions typically meet once a month. And I see we come to a town and we have a lot of things to do, and you come in, and on any given month, there could be 5 developers with different plans. Who has the time to deal with them properly? The answer is not very many. The citizenry who was involved, impacted by it, are put into a dead panic. I mean, I have emails from people, like, please help us. They're going to put us out of business. It goes on and on and on. The individual can't respond in the time frame that's allowed currently for smaller net metering projects. The town governments aren't really well timed and staffed to deal with it. So I would suggest that you'll get better projects and a better end result if you make the smaller projects conform to a more rigorous standard. And at the end of the day, I'm guessing that the developers, and I've talked to a lot of them, friends with some of them actually, that you look at a direct cost of building a project, but there's an indirect cost that's starting to and will continue to appear, which is cost of legal litigations which are going on, time wasted, obfuscation, and it's very important in my view that you look at that 150 because a 150, it's a very simple mathematical issue for you. A 150 usually has an abutter on each side. So you have 2 abutters that produce 150 kilowatt. A 2.2 typically has the same 2 except they're further apart, and except now you're producing 2.2 megawatts. In New Haven, we just finished a town, we would call it a town meeting, it was a hearing, part of our process for writing the town plan. And it's not significant yet, but my general sense was that the average person in our meetings did not have huge objections to a 2.2 megawatt known as cross-pollination. And one of the reasons for it is it's very great distance from the road. And distance is a great thing for making solar projects essentially disappear into the environment. Conversely, if you drive up from New Haven to Burlington and you go through Waltham, you'll see the 2.2 on the left, not obnoxious, and then there are a bunch of 150 jammed up right next to the road on the east side of the road, which most people find objectionable. I guess from California, we're driving up there, his comment was, "What the hell was this?" It was rather startling that was the first comment out of his mouth. So I think the 150s definitely need to have a different process. I would suggest that I got a sense from one of these meetings last night, a definite sense of a drive towards solar, which may be the correct way to go. We in New Haven were pitched by a energy distribution company that is looking at bringing in one case, 400 megawatts of power through a high voltage DC cable about yay big. And you know, it's a long way off, a lot of issues, but very cost effective. And we're looking at 400 megawatts, and that's 4,000 acres. And really that gets to the utility system and all the rest of it, but there are alternatives. And I think we have to keep year over year, keep an eye on technology. There's a little chart courtesy of Bloomberg, which showed up about a week ago. And what it does show, which should come as no surprise, Vermont has the highest cost of solar in the country because we have the lowest capacity factor, because we have the lowest amount of sunshine. Don't have to go to MIT to figure it out. But over time, and I trust that the efforts of the state and of this group looking out, not 5 years, 10 years, 20 years, as the whole country starts going and ultimately we will be into renewables, our portfolio better be pretty good so that we don't have the highest cost of energy in the country or our economy will suffer. So, let's flip through some other quick ideas. Project siting standards.
And I just want to say that I think on these, let's go through these really quickly because we're going to come back to all of these because this is going to be the core of our discussion.
Okay, siting standards. Distance is the key. First of all, a bad site, poorly sited project is almost impossible to screen economically. So, you know, we can come up with screening criteria all day long, and the reality is, the economics don't work, so it's in no one's best interest. So we're looking at some lot line, center line to the road is the way things work in New Haven. Typically 150 if it's a significant view shed area, which is another issue, is 350, so forth. One of the issues we realized was that it's the distance from a domicile that's really critical. That's where the guy lives. And one of the issues that Tony Klein used to, and I have talked about, Tony would say, y'all never going to come up with a solution because every site, every project, every town is different. Well, they are different in many ways. This is looking at distance by a formulaic manner, saying that the smaller the footprint, the less distance you need. So if you're looking at a 1 acre, which is your typical 150 kW, its minimum distance should be 200 feet from a domicile. And if you build a big one, you should be out there at sometimes at a mile. And there's a project that's that's going through the process, and it's not appropriate for me to say plus or minus, good or bad. In New Haven, that's 2.2, and there have been issues. Well, we can see it. We'll see it from here. Well, the reality is, from here was 5,240 feet. It's a mile away, and a mile away, a 2.2 megawatt looks like a postage stamp at the back of the room. You really can't see it. It's there. See 100% of it, but you don't see. You really don't. It doesn't have any impact. So I think distance. You have to look at distance as being much more important. Ground, terrain, and so forth, equally so. Let's go to the good neighbor policy. This looks at almost specifically 150s because, and this is real life in our world, that the typical 150 in New Haven sits on somebody's land that might be typically 10 acres, and the reality is that the guy that's citing it sold the idea that he should, should earn $20,000 for putting this on his property, but he doesn't really want to look at it, so he ends up moving it as far from his property line as he can, and now it's jammed up against the neighbor, and we have lawsuits. We have had nothing but irritation because of that. So our sense is the good neighbor policy says, great, put it on your land, but you don't put it in a place that essentially puts the visual burden, takes it from your world, and throws it totally on the abutter. It's just a fairness policy, and once again, every time you have a firestorm over a small, I consider 150 to be tiny. Anytime you have a firestorm over a 150, creates a severe negative impact in the community, so when a legitimate 2.2 wants to be cited, the guy is put through the ringer because of the ill will created by bad siting. So I really,
Peter, I'm sorry, I'm going to have to ask you to wrap up. I apologize.
well, the rest of it you can read.
We will come back to all these
All right.
suggestions over time. I'm sorry. Thank you very much. Thanks for doing that, and thanks for the introduction. So next is Chad Farrell. Chad's going to just present kind of the challenges from a developer's standpoint, and I'm sorry, same constraints. Basically, we got about 5 to 7 minutes.
I'll be quick.
And then this is something we will revisit going forward.
Absolutely. No problem. Yeah. I can be quick. I don't have any slides, so I'm just going to present a few talking points here. So just a brief introduction. My name is Chad Farrell. The name of our company is Encore Redevelopment. I just wanted to first say thanks to the task force for their hard work on this complicated and important topic. So just Encore Redevelopment, we were founded on the mission to provide 21st century solutions for underutilized property and community scale renewable energy projects. And that's significant. I'll get back to that in a minute. I think it's germane, it's very germane to the topic we're talking about today. Just a little bit more background. I mean, we're generally a developer of commercial scale and industrial scale solar projects. We've done projects from 50 kilowatts up to 3.5 megawatts. About 9.5 megawatts of solar has been delivered across 30 projects since 2010. We're actively developing and construction about 12 megawatts currently. We're 5 folks in our office, but we engage many other professionals across a range of disciplines. So I think, if I had to think about what the biggest issue here is that we're, trying to deal with, it really comes down to the economics of these projects. It really comes down to the dollars. The current scenario of generally securing contracts to build these distributed generation assets at the lowest price per kilowatt hour possible is, is essentially resulting in projects that are generally sited on the cheapest land, generally away from load, and on easily constructible land. Oftentimes, in order to justify these PPA prices or these net metering credit purchase prices, a lot of other things are constrained. I think this is probably why, Peter, you're seeing so many projects in your neck of the woods. The New Haven and the Route 7 area, has the best solar gain in the state of Vermont. It has flat, open land. It has good three-phase service, and it has limited geotechnical constraints. A project that we would do here in Montpelier, would have less solar gain, bedrock all over the place. It's just going to be a more expensive project to construct, and that's going to have an impact on being able to win a contract that's based on the lowest kilowatt hour price. I think we can talk about some of these other constraints around trying to site projects where the customers are located. Burlington is a perfect example. There's just no space for solar in Burlington, at least not for solar at any scale. Town of Northfield is another example. We've looked for projects with the Northfield Electrical Department. They don't have any land. It's a big valley over there. So it's difficult to say that each town should have its own energy needs met, especially through solar. So just to give a little bit of the story of kind of where we're coming from at the top, I said kind of our mission is sort of germane to the topic here. We've tried to focus on landfills and brownfields and rooftops. We've tried really hard to do that throughout the history of the company. We nearly went out of business, and we lost significant market share by doing that. I'd like to just give you all some numbers to sort of reflect how those certain types of projects, which are generally these, the projects that are considered more desirable in the public opinion, landfills and brownfields. 15 to 25% more expensive just to construct. Probably twice as expensive to develop, to design and develop. You know, you've got things like ballasted racking, you've got longer construction timelines, you've got environmental insurance requirements. They're just challenging. Not only that, but we also see resistance or discomfort from these types of site owners. You know, there's this fear of Pandora's box being opened up if we are to site a solar project on an environmentally challenged piece of land. It's not to say that we can't get people comfortable, but it costs money and it takes time to do that. Rooftop solar, often suggested as one of the solutions to this siting controversy. But really, how many large, new, structurally sufficient rooftops are there in the state of Vermont to even put a dent in some of the numbers that Asa Hopkins has presented to the committee? You know, these projects, these are, you know, they're complicated. In addition to the structural capacity, you've got age of the roof, you've got the fact that you may have to pull down the panels at some point during the PPA term, and then you're constraining that building owner's opportunity to do something in the future with his building, whether that be additional HVAC systems on the roof or additional renovations, what have you. So not only do you have those constraints, but you're also looking at 10 to 15% less productivity on a rooftop solar project. Scale is a factor here as well. There just aren't that many roofs that can handle a 500 kilowatt net metering project. And you know, they're going to be more in the 50 kilowatt scale. And you know, just to provide a few more numbers here. You know, we would look at a 50 kilowatt project as 40 to 50% more expensive on a per watt basis in comparison with a 500 kilowatt project. So again, you know, projects such as these are at a competitive disadvantage. You know, people have talked about solar parks, the concept of siting, you know, solar perhaps in an industrial park. Well, industrial parks are pretty, the land value associated with an industrial park is pretty high. So how do we offset the fact that you know, the lease payment is going to be significantly higher, or the purchase price for that piece of land is going to be significantly higher? So those are, you know, a number of the concerns and the issues that we see out there, generally based around you know, the model of trying to procure the lowest per kilowatt hour price for these projects. And whether these are RFPs that we see for bilateral PPAs with utilities, for net metering projects, you know, customers know that they can get the best deal possible out there. So they're putting out requests for proposals for better and generally the lowest price or the greatest discount on the value of those net metering credits wins those deals. So in order to win those projects, to stay in business, people are siting projects where the land is cheaper, easier to build, and easier to permit. So a couple of thoughts as to, you know, how this is obviously the work that you are all doing. It's important work. I clearly don't have all of the answers, but I have a couple of thoughts. You know, how do we encourage the development of these more desirable sites? You know, do we offer a higher solar adder or a price credit for standard offer projects and/or power purchase agreement projects for these desirable sites? I mean, I think if we're going to go that direction, we need to think about a number of things. There's the type of project. Is it a roof? Is it a brownfield? Is it a landfill? We need to think about the location of those projects. You know, what is the general assessed value of that land? And then we need to think about the scale of those projects. Again, a 50 kilowatt project is going to be a lot more expensive on a per watt basis than a 500 kilowatt project. So it needs to be a matrix type of approach. Can we allow for larger projects in some of these more desirable areas? You know, the landfill carve out in Act 99 was a terrific start to that. We're allowed to go up to 5 megawatts on landfill projects. That scale really helps. So, you know, can we push that model into other types of projects? And then third, is there a way to fast track certain sites that are in more desirable locations, more so than just on a per kilowatt basis? The 150 kilowatt projects obviously enjoy a more expedited permitting process. Should we extend that type of expedited permitting, fast tracking approach to different types of projects, regardless of scale? I think that really is what I wanted to cover today, and I'm happy to address any questions or concerns. I guess I'd close by saying, Al Gore was here a couple of weeks ago saying great things about our state for taking the leadership position that we have in the clean energy economy here. And, I think we heard that. Obviously, but with leadership comes challenges and comes issues that need to be resolved and fixed. So I thank you all for doing this important work. It really is critical for our future, for our kids' future. Happy to answer any questions. I'm happy to put these notes up online. Ann and I spoke earlier. I didn't realize you guys were looking for comments to be posted to the website, but I'm happy to clean these up.
No, thank you. We can do that. That would be great. We obviously took notes as well, but we will have you and others in the industry in. This is what you and Peter have teed up for us today is really just the start of this type of discussion that we want to definitely get into more in the next meeting, and I'll do a better job at managing people's time so that we can actually do that. But thanks very much. I appreciate it. Let me ask the panel though, are there any quick questions for either Peter or Chad on what they presented today? Yeah, go ahead.
I'm stepping out now, so.
Okay, everyone at the same time, okay, everybody say goodbye to Andy. Bye. Thanks.
So Chad, my question is this. You alluded to the fact that we, the state of Vermont, have potentially added to some of the choices that developers will make as to the site they choose because of the incentives that the state has put behind these programs. And you talked a little bit about a matrix approach to modifying those incentives to get the results we would desire. Have you put together that matrix?
I have not.
Okay. That's something that I'd be very interested in seeing.
Yeah. I think we could run some models and get some preliminary thoughts out there.
Anything else? Listen.
So I think more of a comment, I think it goes to the bullet points that were made. I just still need to point this out in terms of how successful Vermont has been in terms of the amount of renewable energy that's been deployed in the state. I mean, it wasn't that long ago when really it was virtually nothing, a few net metering. When I put a net meter in my house, which was 7 years ago, it was one of the first in Waterbury. And now, I think we're effectively playing ourselves as almost as good as Rutland.
You had to say that.
So yeah, I think GMP, I think by the end of this year we'll have 100 megawatts of solar in our portfolio, and then by the end of next year that will be doubled to about 200 megawatts of solar. So clearly with that kind of success, then there are challenges, right? Without a doubt, we're experiencing growing things. So I think it's very appropriate to have this conversation and we're asking the questions we're asking. But I want us to be mindful that in fact we're being very successful. As you all know, incredible growth in solar industry and jobs with it. So I get so much sometimes in all the details and the challenges. I just like to point out the positive side of it all.
Thank you. Okay, so.
Well, I just want to add that from a planning standpoint, this is very helpful information, and the same with utilities.
out there who would like to say something. I would ask, unlike the first two meetings we had, where it was kind of general concerns that were raised by the public, I'd ask from now on for the public comment period, could you address the issues that we've talked about today, or the presentations that we've talked about today, so we can build on the information we have and not so much get repeat information. So with that in mind, anyone want to say anything? Yes, sir. And could you please just introduce your name for implementing purposes?
My name is Scott Woodward. I'm a resident of the town of Concord. I just want to echo a lot of stuff Peter said. I served on the planning commission for 4 years, and I can attest to a lot of things that he mentioned, and that how much of a challenge it's becoming to write town plans, and that they are becoming defensive. So I would put a challenge to the task force to do its business without corrupting really the planning process, because, well, I think one of the things we want to try and avoid is for town plans to become so specific and so defensive that there are unintended consequences of doing that, and ones that we can't really predict. I made a comment at the initial meeting about public outreach, and I think that's still an important ingredient to this task force work. So one suggestion I would have is to leverage local energy commissions or any local organizations that might help garner ideas or build support. Like Peter, I consider myself kind of in that middle ground of I'm all for renewable energy development, but doing it smartly. And I think outreach is a big part of that. So as you all are going through the work you're doing, figuring out a way to engage the public more readily. And this one is a broader comment, but it does relate to siting. And I just want to put it in this context, in this sort of a pet issue of mine, is Dr. Hopkins presented last week a development before rec accounting and development after. And if you look, the after part, it's all zero. And I think that's something that we have to bear in mind, is that somewhere in this process, we have to remember that for now anyway, and I don't know at what point in the future we start counting recs towards the state's targets, but really in essence, by selling the vast majority of recs, we have to really take that with a grain of salt, how much progress we really are making. And so, and I only raise it only because by selling recs means we have to do more development, and more development means more signage. And so somewhere in the state's policy piece needs to consider at what point do we start transitioning and counting more of the recs towards the state's goals. Because otherwise, what is all this good for if we're not actually getting recs to count towards the targets? Thank you.
Great, thank you very much. Appreciate that. Other comments? Yes, sir.
My name is George Gross from Charlotte. I'm probably one of the few people in this room or anywhere who has been in both an active role for the last few years in an Act 250 proceeding and also in Section 248 as a pro se litigator. That was in the Phase 2 gas pipeline project proposed by Vermont Gas. That project got canceled, as you may know, from economic reasons. I had a pretty much front row seat as far as being a property owner on the route, and understood fully the criteria that was brought up here earlier today. I have several observations on the basis of that experience. I should also mention that I also have in our household at CPG, we do run a solar project at our house, as we are generally net zero for most months of the year. So I'm sympathetic to solar, and obviously I would like to see it deployed at a wide scale. But I'm very concerned that the current trend line will not do well given the political currents that are out there. I'm also particularly concerned that when you look at Act 250, you might be misled to think it's a panacea for the permitting issues and aesthetics issues. But in fact, it's just as expensive for anyone to litigate in that realm as it is in Section 248. It's easily possible for a town or a group of citizens to spend several $100,000 in litigation expenses. In other places around the world, if you look at what's possible for interveners process. The Public Advocate's Office is a separate entity from the executive branch, and it is funded in a way that allows for multiple interventions by different groups, clusters of people with different stakeholder interests. So instead of having one monolithic representation for the public in the proceeding, there's multiple interveners representing different stakeholders, whether it be ratepayers or landowners or other parties that, for example, in pipeline, you might have someone who's an environmental group that wants to intervene. So with that in mind, I'm also mindful of the fact that solar has a unique problem in that it requires lots of real estate. And invariably, the more real estate you involve, the more stakeholders you have, because there's all these adjacent landowners. So in thinking about this over the last several weeks, it seems to me that the concept of concentrating solar projects, clustering them together where there are relatively few landowners, or if better yet, if the solar park that is developed is actually a park that has adjacent land bought out and previously cleared of stakeholders, that would be the sweet spot. I also would point out places like Shoreham are traditionally very agricultural and understandably defensive about making the soils and farmlands move to solar projects. And for that matter, the tourism industry in Shoreham would definitely take impact from large-scale projects. So all these things seem to argue for having three-phase power extensions to a place that nobody's going to see it, and that many of these projects be placed in the same location. One final closing thought. My wife and I, along with several other parties in Shoreham, created a community-owned solar cooperative company last year. We ultimately had to table that because of the expense of adding a three-phase line extension to the site we had in mind on town land. It would have been a good site. In fact, it would have been a good site for a multi-megawatt site if you had the resources to do that. But the initial cost of getting connected to the grid was substantial. All these things that are barriers to acquiring the correct site and the correct infrastructure suggest to me that there need to be socialized costs. In some way, legislation they're developing has to somehow make it easy to place the solar in the right place. That's being able to meet all these different criteria that we talked about.
Great. Thank you so much. Appreciate it. Anyone else? Comment? Yes, sir.
So, I'm going to bring that development, solar developer. Just want to say that we had a lot of farmers approach us to help stabilize their financial base, to get the lease payments that we pay to them. So it makes quite a difference to the scattered farmer. We've turned down a lot of sites too because we go there and we look, and I saw Billy Costa here earlier. We do wetlands analysis, we do rare, threatened, endangered species analysis, and they just don't cut it. So we have to drop those sites, a lot of those sites, and so we really wind up being very picky about the sites we choose, and we always, as Peter was saying earlier, we do 500 kilowatt sites, and so we always try to be as far away as we can. We always like to be over the other side of a ridge from the 7 or whatever, Route 100, wherever we are. So just want to applaud the work that the commission is doing, this committee is doing, and let's talk together and get more stuff out.
Great, thanks. Anyone else? All right, I thank you all for your patience and for the committee for being willing to stay extra. Does anyone on the task force have anything else besides the motion to adjourn? Thank you, Sharon. Seconded. Thank you, Grace. Moved and seconded to adjourn. All those in favor, signify by saying aye. Aye. Opposed? Anybody who wants to abstain can stay. Thank you all very much. Next meeting is the 3rd of November. It's meeting up, so it should be in this room.